welcome to You and the Law. I'm Mike Monda, your producer and host for tonight's program. And today we're going to talk about a very important to you, the viewers out there, and to us in the legal community. We're going to be talking about social media in the law. And joining me as our special guest for tonight is Mr. Glenn McMurray, an attorney and partner with the Dungan and Lefevre law firm in Troy, Ohio. That is correct, isn't it? They might have other branches somewhere. And we're going to be talking about a lot of things in social media, how it affects you, how it affects the law, and interactions. We'll be talking about Facebook, Twitter, LinkedIn, Instagram, and anything that you, the viewing public, asks us about. Before we get started with our first questions for Glenn, let me remind you that You and the Law is a monthly presentation produced here at the studios of the Dayton Access Television. DATV on Time Warner. It's Channel 5 here in Dayton. Channel 6, I think, out in the suburbs, is the public access channel of Time Warner here in Dayton, Ohio. Programs also cable cast north and south via the public access channels. 6, there might be some 900s in there, and that's through the auspices of the Miami Valley Cable Council. Executive producer for the program, the originator of the program back in the 80s. Yes, there was television in the 80s, former domestic relations judge Mike Brigner. And this is a live call-in show. There will be a number, and there it is, 223-5311. If you have a question, comment, whatever, for Glenn McMurray, don't ask me. I'm going to refer them all to him. Call that number, and we'll put you through, and we'll talk about it. We also live stream on datv.org. If you're watching TV, I guess you could switch to that. If you're not watching TV, you just have to know about it, I guess. But we are seen coast to coast, and probably the rest of North America if they can get that. So let me turn to Glenn right now and ask him to introduce himself more fully, tell you about his background and familiarity with today's topic, which is social media. Good to have you with us, Glenn.
First, Mike, thanks for having me. A little bit about myself. As Mike said, I'm a partner at the law firm of Dungan and Lefevre in Troy, Ohio. My primary areas of practice is typically business litigation and advising businesses on various aspects of compliance, including their use of social media. Companies use social media as well. And one of the niches that I have researched over a number of years with several colleagues is the impact of social media on individuals as well as companies, and what some of the legal implications of social media are. So again, happy to be here, and looking forward to answering some questions.
Okay, thank you, Glenn. Well, why is social media important in the law and in our everyday lives?
Well, we have a few slides for today, and I think probably the first one, which is the why is it important slide, is the by the number slide. So if we could pull up the by the number slide.
All right, let's see that one. Is this the one you want?
Correct, yes. And here several years ago, there was a white paper written about what people were doing in terms of searching for specifically attorneys and how they were finding attorneys for their various legal needs. And what that study found was that in 2012, and that number has continued to grow, in 2012, 58 million consumers were searching for attorneys. And of that 58 million, 76% looked for the attorneys online, which ended up equaling a little over 44 million people were looking for attorneys. And in order to find an attorney to meet their legal needs, they used the internet to do so.
Okay, so I've got a question here.
Yeah.
I'm butting in, I guess, but so where does that leave the yellow pages? Everybody used to look in the yellow pages. There were big ads or the newspaper. Has that gone the way of the horse and buggy, or Is it still compatible with the?
I think the Yellow Pages, at least for many areas of industry, has in some ways, worn out its time, has kind of gone by the wayside. I know amongst my firm, we regularly have a discussion when we're considering whether we renew certain aspects of our advertising, whether or not we're going to keep a Yellow Page ad in lieu of more online or internet marketing. And usually that discussion is typically resolved in favor of focusing more on internet marketing. I think what you see with traditional print advertising is that more local, community-driven print advertising is still prevalent for, at least amongst attorneys, certain areas of practice. You will customarily see estate planning attorneys and perhaps criminal defense attorneys and more general practice firms, advertising in sports programs. You will, for a local school, because that's a market that they are focusing on in an effort to stay relevant in their community. And so that type of print advertising, I think, persists. However, even those schools, those local communities that offer the print advertising opportunities, what you're seeing from them in response to internet-based advertising is those local communities that used to offer a typical half-page ad in their sports program are now offering internet-based options because they know that it will provide their sponsors more exposure, but will also provide the school or the community-based organization more exposure as well.
Okay, now for the novice with the computer, and I think 10 years ago, what you're talking about probably didn't even exist, or if it did, in a minimal sort of way. The people that would say, I need a lawyer, or I need a plumber, or whatever, that pick up the great big fat Yellow Pages and start thumbing through it. What typically, for someone who is not well versed in the computer, but they've got one, they know that there are websites and they know their categories, and if you type in anything, you can probably find that category. So what should the consumer be doing? Let's say if they've got a legal problem, or maybe they just want to do a will, or maybe somebody is charged with something, or they need a divorce, or whatever.
Well, what you're finding for the consumer when they're looking for an attorney, what you're also starting to see is you're also observing many Angie's List for the legal industry organizations that are popping up. So you'll see Avo or Law.com or various other websites that are that advertise to be ratings-based websites that are evaluating whether or not an attorney is good at a particular aspect of the law, good at being an attorney generally. At those websites, again, much like an Angie's List type of format, you see customer ratings, you see client reviews being written and published, and you see some interesting things that are geared toward trying to protect the consumer, or at least better educating the consumer on the attorney they're about to select. In many ways, however, I think the best thing an individual can do when they're looking for an attorney, the internet is not. Some people have cast internet advertising as anybody with a computer can put an ad out there that they're an attorney to try to invite someone to the web.
Well, you'd have to be an attorney.
Right, correct. You wouldn't be, our state bar would be very persnickety about that, I believe. But believe it or not, it's still a relatively costly adventure to advertise effectively on the internet. So while anybody can create a website and advertise that they're an attorney, it costs a significant amount of resources, both in time and money, to make sure that your ad is one of the first few that show up, or whether it shows up on the first page when you're searching for an attorney. And so what I would recommend to individuals searching for an attorney is feel free to conduct a search. Use Google, use whatever search engine you want to do, but there is no substitute for evaluating several and trying to get a feel for a particular attorney's aptitude compared to others, and really finding that comfort zone with your attorney when you're forming that relationship.
Does that have any degree of reliability? It seems from what you're saying that maybe if you've got more funding or maybe more of an expertise in making up one of these things, you might be a little better off than somebody that just says, I'm an attorney, I do this type of cases, come see me.
Yes and no. Correct. Usually, a well-funded larger firm is going to have a bigger website than a solo practitioner. I don't believe, though, that's necessarily an indicator of aptitude for practice. But that's while it's all the more important for an individual, I think, to interview their attorneys, and maybe interview more than one if you have the time and ability to do so. Because as great as the internet is in terms of providing information to individuals and giving them the ability to sort out what's out there or discover what's out there, it really is a poor substitute for getting a good read of an individual, asking them questions, and seeing what their type of response is in person. And that's why you need to use the internet with caution still. Okay. Particularly when you're searching.
So maybe coordinating that with the old tried and true word of mouth type of thing. Somebody says, I had a great attorney. You ought to go see him or her.
Absolutely. Right. And one of the issues too, and this goes with customer reviews, is unlike some of the other service-based areas, plumbing or fixing something on your house, it's difficult to gauge one particular client's experience with an attorney to what maybe you will have as an experience with that
Every
attorney.
Case is different, isn't it?
Every case is different. Not every case is winnable.
Right. Okay, we're going to take a very short break. We've been on air for about 15 minutes to let you, the viewing audience, know that you're watching You and the Law. And we're talking about social media in the law tonight with our expert guest, Mr. Glenn McMurray, with the law firm of Dungan and Lefevre. We're sponsored by the Dayton Bar Association, and they've been very nice to us, putting us on the air for a number of years. They have been in the Dayton community since 1883. How many years is that? I ask that I ought to know the math by now. It's 100 and
oh goodness, Mike.
122 years, a little longer than we've been here. So anyway, Bill Wheeler is the director there, and I've been doing a fine job over the past years. And the Bar Association provides a number of community service for the benefit of our Miami Valley citizens. Some of those are lawyer referral service. If you don't have a lawyer for your particular case, nobody can tell you about it. You can call a number, 222-6102, and they will assist you in locating a lawyer for your particular problem or area. If you wanted to be a notary, they have applications and testing. We make sure the notaries really know what they're doing, and after they finish these applications and testing, they do. I was on the committee once, and I don't think it had anything to do with me that they were so good, but they learned the stuff in the books and took the tests and passed. So very important program we have is Wills for Heroes program, which volunteer members of the Bar Association will create basic wills for emergency first responders, firefighters, police, EMTs. If you are one of that category, you don't have a will, you're interested in it, call the Bar Association. I'll give you that number too. It's 222-7902. And if you don't remember everything I'm saying, that's in the phone book. And it's also online if you typed in the Dayton Bar Association.
They covered both meetups.
It's amazing. The website is www.da ybar.org, and that gives the information, guides, services, legal links to the courts, which is important if you're going to court. And a volunteer lawyers project, which serves the disadvantaged, and founded and supported by members of the Bar Association. So that's some of the things that we do. We're proud of the association. We're proud of our members who are doing well for not only themselves but the community at large. So thank you to the Dayton Bar Association. I won't go through that again. And Bill, if you want to call in, you got more. If you're watching, let me know. So we're talking about social media. In the law, we've talked about using social media to contact attorneys if you need one. And what I'd like to talk about now is some of the concerns with use of the social media, how I guess you can get in trouble or maybe get out of trouble, or whether it's helpful or hurtful, and how so.
Oh, absolutely. And you know, we talked about some internet advertising. We talked about some of those features that make the internet so appealing. And social media is how many individuals, attorneys, and prospective clients alike access the internet in order to find the information they're looking for. But the use of social media in particular as a mode to communicate or to access this information can come at a cost. And so there are several noted cases where clients have gotten themselves in trouble because of their social media use, where the legal implications have been very real and sometimes very, very harsh. So I think one example, and it usually gets some good laughs, is the CNN slide. So I'd like to pull up the CNN slide. So this is a slide that usually gets quite a few laughs.
You wouldn't think that'd be possible, would you?
Right, exactly. So this is a slide where a girl's use of social media, a daughter specifically.
Everybody's got Facebook.
Yeah, everyone has Facebook, and a daughter's use of social media came at a true price tag, and in this case it was $80,000. A little bit of background about this case. This was an age discrimination case out of Florida that was filed by a administrator leaving a school district. They were able to resolve that case and came to a favorable settlement, but usually when a case is settled, there is an aspect of a settlement agreement called a confidentiality provision. And what that confidentiality provision provides typically is that a party cannot reveal any of the details associated with the settlement, nor can they really further iterate on the case apart from the fact that it was resolved. Well, in this case, the daughter of the gentleman who had filed this age discrimination suit,
she had nothing to do with the lawsuit, or
had nothing to do with the lawsuit. She was simply, one of the supporting cast of characters in this gentleman's life. She was happy that he had come to a resolution. And so if you'll move on to the next slide associated with this, that's an actual reproduction of what she posted on Facebook. She was excited for her father, and so she wrote, "Mama and Papa Snay won the case against Gulliver. Gulliver is now officially paying for my vacation to Europe this summer." And as the headline at CNN read, "Suck it." So she
is meant to go to Gulliver. I guess.
Exactly.
Okay.
So she did, as the court in Florida specifically found, she did exactly what the settlement confidentiality provision was aimed to prevent, and that was to disclose that there had been a financial payment, to disclose that there had been any type of resolution. Of that nature, where one party perhaps got a favorable result more than the other. And so what that ultimately resulted in is it resulted in the father losing the benefit of that settlement. and thus this young woman's social media use came at a real price, and that price was her father's age discrimination settlement.
Okay, so
I have one more slide on this.
Okay.
If you could go to the next slide.
yeah, let's do that. Let me ask our people in the control room, put our call-in number, in case I've forgotten it myself. I know it's 223-5311, I think. Is that right? There you go. Leave that up for a little while. Maybe somebody will call us. Okay,
So,
go ahead.
but as you can see, that use of social media got a big thumbs down. I mean, it really came at a price, and it frustrated the very purpose of that settlement provision.
But this was somebody who thinks they're just innocently using the Facebook. Thinks maybe a few friends will see it and say, "Hey, good for you," and it turns out that once she posts it, it is available for even the opponents of the lawsuit to get.
Absolutely. I think one of the interesting aspects of social media use, and this is somewhat ingrained in us culturally, at least with our social media use at this point, is we really feel that it is a private forum. Mm-hmm. We do not believe, even though the opposite is true, we do not believe that the information we put out on social media is readily consumable by the masses, when, again, in fact, the opposite is true. And so people detach what the consequences are of their use of social media from their actual use of it. They will put something out there and feel that it didn't really count. Mm-hmm. It didn't really have a true impact on what they were doing. And so it's odd how we treat that, but that's all the more reason why an individual's use of social media really you need to exercise caution and use a little common sense when you're using social media.
Okay. Did you have another slide to go with this?
Yeah, I have another example, and this is one that actually, this is more of a fabricated example based off a real-life event that occurred in my practice. I had represented a client at one time who was charged with a particular crime, and I had been retained by a special interest group to help this particular client out. Really, really lovely person. This is just a joke. This was not actually what happened. But there exists, as you know, Mike, when you have a client, there exists something called the attorney-client privilege. And the attorney-client privilege means that I cannot be compelled, nor my clients can they be compelled, to disclose any of the advice I give them in the context of my representation of that particular client. However, that privilege disappears if the client voluntarily discloses what I have given them or told them in terms of advice.
Okay, now tell our viewers, generally when you're talking with your own clients, the advice is tell them you're talking about their case, you've gotten all the information to them, and what does the attorney tell the client in 100% of the cases?
Oh, I know I tell my clients regularly, and now I add a little bit to it given this circumstance, but I tell my clients regularly, I don't want you disclosing or talking about what we talk about. You need to keep that quiet, and I tell them it's because of the attorney-client privilege. But again, this goes back to what we just mentioned, which is people detach the consequences of their social media use. So the example I gave on the slide was, got away with it, my attorney tells me that they cannot ask my wife about the robbery we committed, something about spousal privilege, lots of laughs, LOL. And what that would do if that person were retaining an attorney who had in fact told them about the spousal privilege, that would waive their privilege. That's them disclosing advice that they had received from their attorney in the context of that confidential privileged relationship. In my case, my client had a support group on a social media outlet, and every time, unbeknownst to me, we would meet, she would report back to her social group some of the contents of what we had been discussing and all of the aspects of that person's case.
Now, usually it would be good for the client to tell other people how good their attorney is, without being so specific.
Correct. And that's one of the actual advantageous things about social media is it provides a level of community to individuals. But in this case, my client and the example we gave waived privilege because of that.
Okay. Our floor director tells us we have a call waiting, so we will take that call. Good evening. You are on You and the Law.
Hi, thanks for taking my call. My name is Kathy, and I'm calling from Maryland. I apologize if you've already covered this. I tuned in a little bit late, but my question is, I've heard a lot of instances in the media of people being fired from their jobs for things that they posted on social media, or students being expelled or punished at school. And so I'm just wondering, I guess, first, what's the legal protections that people have? I don't know if people have a First Amendment right or something that would protect them in those instances. And second, I guess I'm just wondering how it's fair to punish somebody for something that they're doing in their own personal time.
Kathy, that's a great question, and actually it's been a very popular topic recently. In fact, over the last few years, the NLRB, which is the National Labor Relations Board, has issued some decisions on this very issue. And usually those decisions have come down that an employer cannot typically take an adverse action against an employee for their social media use if it meets several key factors, and there are many of those factors. And I don't have them all here to go through in detail, nor do we really have the time. But some of them are really kind of common sense factors. Like first and foremost, I'll give you one example that the National Labor Relations Board has evaluated. A catering company was found to have been prevented really from taking an adverse action against an employee when that employee engaged in discourse in social media that was concerted, meaning organized with other employees, when it was aimed at improving the job as opposed to just disparaging the employer, and when really it was more positive-driven comments about how they can improve, again, aimed at improving their performance. And in that case, because she was saying, I think she had said that their last event was somewhat of an embarrassment and they wanted to do better, and they didn't like the way the previous catered event went. In that case, they found that they could not have engaged in an adverse action against the employee because of those. They met those factors. The opposite example has been evaluated where, for example, a bar owner had a bartender who said, "Oh, I hate all of our bar patrons, and I wish they'd choke on glass." I think that's not too far away from the actual quote from the individual. And in that case, they found that no, that wasn't really a concerted effort. It certainly wasn't aimed at improving the business, and it wasn't aimed at improving work conditions. And so in that circumstance, they could take an adverse action. However, very recently, and I believe within days, there was a decision, I think a decision out of New England, I believe around where you are, Kathy, that found that an employee's using maybe some expletives on their personal time could not be the subject of a termination by the employer. That was protected. So that's a very good question. It's still somewhat an area that's in flux. But there is a level of protection for employees from having an adverse action just because of their use. Mm-hmm. But there are still consequences.
Okay. Does that answer your question? Do you have any follow-up?
No, it seems like maybe the option is not to put anything on social media.
People always ask me, is social media a good thing? You tell us all these horror stories. Should we just quit using social media? And that's not what I advocate. I think social media is a very effective tool to get messages to large groups of people. We give these stories because we just want people to exercise caution, and so. In some cases, common sense should maybe prevail in terms of how you're using it, what you're using it about, how you're directing it, maybe the specificity in which you are using information on social media. But I certainly don't think it means that you shouldn't use it. I think it just means that you should exercise caution.
All right. Thank you for your call.
Thank you.
All right. We have about 25 minutes left. I see on the monitor you're watching You in the Law. We're talking about social media in the law with our expert guest, Mr. Glenn McMurray.
I appreciate that you think I'm an expert. I don't know if that's the case.
Of all of us in the studio here, you're the one who can answer these questions, and you do have quite a bit of expertise. I think you sold yourself a little short with all the things. Look at this. We even have another caller. We'll take a call. Good evening. You're on You in the Law.
Hello.
Hello.
Hi, I have a question.
Go ahead.
All right, my name is Darla, and I was wondering, I've heard instances where employers were requiring either employees or applicants for the company that they had to give their passwords for social media, their Facebooks or their Twitters or whatever. And I was wondering, is that illegal, or, as an employee or as an applicant, can you say no and have some type of action against an employer for requiring that?
That issue, admittedly, I am not sure if there's been a ruling on that particular issue yet. There very well may have been a ruling on whether or not, to repeat the question, whether or not an employer can require an individual to disclose their social media password and information. Now, first and foremost, you do have, in some cases, a right to privacy, but employment in many states is an at-will employment state, and so an employer, unless it's for one of the restricted reasons, discriminatory reasons, an employer is not really subject to that much scrutiny in their hiring process unless they're really encroaching into discrimination territory, whether it be based off disability, race, gender, ethnicity. So when it comes to whether or not you have to disclose a Facebook password or your Twitter password, I don't know if there's been a ruling on whether or not that is specifically prohibited. I would be stunned, though, if it is permitted to continue. That said, in many cases, employers can require background checks, and they can require you to disclose your Social Security number. They can require you to disclose information about your criminal history, so on and so forth. They can, if they see fit, pay for even a more expensive background check, which can go through the FBI protocols for background, which I would be stunned if that did not include some aspect of looking on social media. So, my gut reaction is I think that they can only require that, or what will come down is that they will only be able to require that for a very limited purpose of their evaluation.
That's what I was
employment.
thinking. Sounds like a big invasion of privacy to me.
A very limited purpose, but I don't know if they'll be outright restricted from it. But then again, I'm not really sure if there's been any decisions on that as of yet. Hope that helps.
Okay, thank you.
You're welcome. Any follow-up?
No.
Okay, thanks. All right. That is an interesting. I wasn't aware that sounds like a problem to me.
I think employers are going to probably.
I think this is only for private employers that they're doing that, though. Did you get that impression?
That's the way I understood the question. I think. I don't know if I don't know. Just seeing where the law is gone in terms of other privacy aspects with employment, I don't know if it would be an outright restriction. I think, frankly, an employer is probably opening up more of a can of worms by requesting it than the useful information they will receive from it.
I mean, what would be a purpose of getting people's private information or monitoring it.
Right, and I think the issue there is perhaps they're looking for affiliations, certain aspects of maybe of an individual that they don't want for the ideal employee in that setting. But typically I don't, because of how pervasive social media use is, I don't know if there will be a huge distinction in a Facebook use by a new employee than there will be from the president of the company, because it is so pervasive.
Yeah, okay. Well, those are a couple of pretty good calls. We have about 20 minutes left. Yes, 20 minutes, and you're still watching You and the Law, I hope. You haven't changed to Jeopardy. If you have, you won't be listening to me. You might find out way more listening to Glenn here, talking about social media and the law. That's our topic tonight on You and the Law, and you can see our number there. There's still time to call in if you have a question, which you can't find on the internet, social media, because you'll get a more comprehensive answer from Glenn McMurray right here. So any other problems that have, and I think when we were talking earlier, social communication basically starting in the mid-90s, took off in the mid-2000s. Seemed like a good way to connect with grandma and the kids who have gone off to school or something like that. And it's you can actually commit crimes on social media, I guess, can't you?
Oh, absolutely. I mean, you see, they coined it. The popular phrase is called revenge porn, is what people are calling it. And you'll see, people who were in a relationship disclosing perhaps sensitive material, photographs, or other information via social media or on the internet in general. It's much easier, I think, now for people to reach the masses than it ever was before, in part because everyone, it's one big common venue. It's a big tent that everyone is under. And so when you disclose something, it can just spread like wildfire if the conditions are right. And
so that old photo that you used to be able to burn in the fireplace, and that was the end of it, isn't necessarily when you pick up your phone and send it to at least one person.
Oh, absolutely. And that, if you share it on your page. Now, one thing that I always caution clients, individuals, really everyone about is, when you're using social media, Facebook, Twitter, LinkedIn, Instagram, any of those feeds, is you should know what the privacy settings are. And this is a very popular topic right now, is know what your privacy settings are. But even with those privacy settings, you need to be aware that there are terms and conditions that apply to your individual relationship with that social media provider. When you are on social media, you have an agreement with Facebook and you have an agreement with Twitter that dictates your use of that medium. And so because of that, you just need to be very mindful of really the rules of the game that you're playing by when you're on social media.
Okay, our floor director tells us we have another caller waiting, so we'll take that call at this point. Good evening. You're on You and the Law.
Hi, thank you. This has been a very informative show. Thank you for having this topic on tonight.
You're welcome.
I have a question for you, and that is this. I am a graphic designer, illustrator, and I do work for my business. I'm a hired contractor, but I don't do things on my own that I'll post to my website. And people will essentially steal, repost it with giving me credit. And it happens quite often, and I'm not sure what course, if any, I have to maintain control of that distribution, what copyright rules are in place.
Well, again, that kind of goes by the rules of the game you're playing. So there are copyright protections for individuals who create art, graphic designers, who create a medium that protects that from someone just taking it, running with it, and claiming credit for that as if it were your own. You do have copyright, sometimes trademark, in some cases, patent protection for some of those aspects of your trade. But again, a lot of it depends on what the rules of the game you're playing by dictate. So, for example, think of certain social media feeds as a art warehouse. In some cases, when you agree to display art at a showroom, you're giving up some of the rights to that art. Okay, and so the same will apply when you do that on Facebook, or when you do that on LinkedIn or Twitter or any of those other social media venues, because those rules are going to govern, and they vary from medium to medium. And so part of the protection for you creating that art, and I have friends who are graphic designers who lament about this exact problem, is to know at least what the rules are for the medium that you're using most. Because that way you can, at least with some predictability, know what you're giving up when you do share that information on social media.
Does that answer your question? Do you have any follow-up?
Yeah, well, I understand, putting things on Instagram or Facebook and how that, you're sort of giving it up there. But when I put it on my website, people maybe just scroll through or find a link, and then the next night I know somebody else is posting it on their Facebook page and saying, not even giving credit. And so I don't know if that, in terms of the rules of the game, if I put them on my own private website, if there's any recourse there as opposed to me posting it directly to Facebook or LinkedIn or Instagram or whatever.
Yes, and that is a big distinction. I didn't quite grasp that distinction with the initial question. If it's off your website, you do have typical regular copyright protection to information that you share on your website. So if you have an original artwork on your website, much like many of the stock photo companies do, you cannot just use their stock photos without paying for them. You have a similar copyright infringement or copyright violation protection where you could go and file a lawsuit prohibiting their use of that copyrighted material. And in some cases, you can have your fees paid. Part of sometimes what people run into is you need, particularly if you're trying to disgorge another individual from profits they may have obtained. Sometimes the process, though, of filing a lawsuit on some of these, unless you have real, significant damages that you can quantify, the obstacle is usually the cost of getting to that point where you can have some recovery. But a claim, if it's coming from your personal website, would I believe be there.
Okay.
Thank you for your call.
Thank you very much.
All right. Okay, we have a dozen minutes left. I wanted you to put up the, if it's related to anything we're talking about here, your how much is this shirt worth slide.
Certainly. So this slide is actually from another real case. The great thing about these cautionary tales is they always have the best material. This was a case out of, I believe, Virginia, if I'm not mistaken, where an individual, a husband, had sued a concrete company because there was an accident involving a concrete truck that tragically had taken the life of this individual's wife. And so he sued that company for the wrongful death of his wife, and included some claims for loss of consortium or companionship with his wife, and he included some, he wanted to be compensated for that. Well, during the context of this case, the concrete company's attorneys discovered that he had in fact been living a rather inconsistent life for someone who is mourning for a spouse, and that there were many pictures of him on social media wearing shirts exactly like this that showed him, partying and really something that wasn't quite consistent with someone mourning a spouse. And so the concrete company requested that information. They said they wanted to see the pictures of him on Facebook at certain particular parties, including a party where he was observed wearing the I Heart Hot Mom shirt. Well, the attorney, and this is a cautionary tale for both clients and attorneys. The attorney, when he caught wind of this request, had his paralegal, his assistant in his office, contact his client and tell him to clean up his Facebook page and to take these photos down. Well, when that was discovered, sometimes, as you've heard before, the cover-up is worse than the crime. There was several legal battles that ensued about whether or not this individual spoliated the evidence and destroyed the evidence that the opposing party was trying to obtain. And what ultimately ended up happening was the court awarded sanctions against the attorney and against the gentleman who was filing the lawsuit in the sum of over $700,000. And I believe the attorney paid for over $500,000 of that sanction because of a simple call to a client telling him to clean up the Facebook page. So that shirt was worth nearly $750,000 because someone was trying to cover up something that if they had just turned it over would not have been bad, or as bad. So, a cautionary tale to attorneys and clients alike, use caution with what you're putting on Facebook, but particularly if you're in a lawsuit or litigation, you need to be careful with what you're doing to that material after the fact, particularly if an individual is being requested to disclose that information.
I guess it wouldn't have been so bad if he just wore the shirt and didn't put it on social media then.
That's probably a fair characterization. One thing that it goes back to privacy settings. You do have an example is on Facebook. You have a privacy setting that does not allow people to tag you in a photograph unless you give them permission for that particular instance. And
I'm sure 3/4 or more people do not know that or know where these things are.
And so there are settings. There are many resources that you can find to figure out those settings, but that would have been one that probably would have maybe helped them out a little bit in that circumstance.
Right. Okay, our floor director tells us we're kind of winding down. We're not out of show yet, so we talked earlier about maybe some best practices type of thing, and I know you have a few more slides, and maybe let's look at those in the time we have left here.
Well, social media best practices, and my colleague who does this presentation with me from time to time, we develop these. This applies really to attorneys in many ways, but it also applies to individuals, consumers, clients, people watching the show as well. And so one of the first rules is encourage clients, which is clients of us, to connect with you via social media, but advise them that all legal communications must be conducted by private email or phone. This goes back to the cautionary tale. We talked about people disclosing attorney-client privilege communications. Part of the other issue about social media is know your audience. You need to know who's viewing you on social media, and that should guide you in what you post. You should ensure that you have written permission from your clients, so clients of attorneys, before you can disclose them as representative clients. That's an issue that attorneys run into, saying, hey, I represented that person. You need to have permission to do that. Now, this applies for both attorneys and clients. You need to engage fans, engage people that are going to follow you by commenting and publishing. The great thing about social media is it's an avenue to publish without the expense or difficulty of publishing. But at the same token, you need to use it in a method that's meaningful. strive to be a rich source of information for people. Always monitor your social media sites. Immediately try to claw back anything that you feel should not have been disclosed.
Let me ask you about that. You put something out on, you generally put something on social media. Can other people, and they talk about Wikipedia and stuff, can you add stuff to it, or which makes it incorrect and maybe jeopardizes the person who's putting it out in the first place?
Well, the answer to that question is yes. Now, if you were to publish something or have a post, I'll use Facebook as an example because it's the most used. Someone cannot alter your post.
Okay.
They can comment on your post if you have given them permission to comment. Again, that's another privacy setting that you can utilize
a friend or something.
Yeah, for your protection. But they cannot necessarily alter what you have already written. They can, however, copy it and try to publish, just like anything else, as if it were you. And that's something that you need to police and regularly try to monitor, particularly if it's something on your particular page or profile.
So if you were an attorney putting all the ways to beat those DUIs on there and somebody else used your thing, then you might have some action.
If it's on your private website, again, that's kind of a different, you can use that. And
that was euphemistic,
yeah,
by the way.
Correct. But really, and this is why it's repeated 3 times, the biggest aspect of this is not to avoid social media, but to use common sense.
We're kind of in the infancy of use of social media, aren't we?
Well, actually, no. I would say
we're past toddler stage.
I think we're no longer in infancy. Okay. I mean, social media has been around for over 2 decades at this point. People are using it. There are sociologists who are studying how we use it and how it has impacted us as a society. And so I don't believe we're in the infancy any longer. I think we're in that point where we're trying to see what it's done to us and how best we can meet the goals and ideals of our society with this here, because it's here and it won't be going away anytime soon.
Okay, we have 2 or 3 minutes. It looks like 3.5 minutes. Tell our viewing audience maybe some things that they should do or not do that we haven't talked about.
Okay.
I'm sure there's some.
Okay.
I'll cut you off when we're completely out of time.
Well, one thing that I always tell people when you're dealing with whether or not you're going to use social media or clients, if the question ever crosses your mind, should I do this or should I post this or maybe I shouldn't do this, then the answer to that question is generally always no. So
same stuff your mom and dad told you.
Exactly.
When you were a kid,
the rule. We used to say this about email is take a minute before you hit reply all. Take a minute to think about the substance of what you're going to be putting out there, because the difference between the age in which we live now and the paper age, where you would send a letter, is you had to take time.
Right.
To create that response, to generate something that was articulated and focused to the information you had received. But we're so much more prone now because of our tools to do a knee-jerk reaction that we just need to take time. You need to think about what you're putting out there and just be cautious with it.
Yeah, you used to have to put it in an envelope, and I guess once it's in the envelope it might go, but it's way faster this way, isn't it?
Right, absolutely.
Okay, what do we see in the future of having more expertise in controlling media communications from our law firms, do you think?
Well,
I'll give you a minute here.
Right. Well, I don't want to be remiss without thanking my colleague. His name's Michael Zussman.
Do we have that slide?
Yeah, I believe we do.
Did we see it already?
I don't know if we've had that one out, but he's at the law firm of Cowan Debates and Abrahams and Shepard in New York. We've done this program or a version of this program around the country, and we co-developed it, and so a lot of credit goes to him. But where I see things happening, truly, a movement that you're seeing in Europe right now is the right to be forgotten, and so that's something that I think is going to be. That's where people can petition to these social media websites and providers to remove their information. And so I think we might see an aspect of that in the United States at some point in our future, which I think people are going to need some assistance navigating.
Okay, thank you, Glenn McMurray. We have run out of show now. You've been watching You and the Law. It's a production produced here at the DATV studios, designed to bring Montgomery County citizens news of the legal world around them. I want to thank all the volunteers behind the scenes who have made this program possible. I want to thank also our callers in from around the state and around the country, and especially thanking Glenn McMurray for his time and expertise here. I've been your producer and host. I'm Mike Monda. Thank you for joining us. Tune in again, and good night, Lily and Katie, wherever you are. Good.
Thanks so much. Appreciate it.
Did you enjoy it?
Oh yeah, this is great. It's great.